OKFM 101.7.
Lawyer Edudzi Tamakloe, private legal practitioner. You didn't claim come on and sembia who he a family camp so. Law me watching.
Black Kwame no primary also.
Nabokodi.
Obwadi adaroma Black Kwame.
Na mami fa wo free say. Oru agye question. Supreme Court to say ma on holding himself upset wo ye mrahye bedwani. Anasa asem no de ni nwie na mum injunction application July High Court no rule ye no and Supreme Court no so affirm the earlier decision of the High Court. Say the city pa.
Okay, so there is a existing judgment of the High Court restraining him perpetually. Now there is a new order from the Supreme Court restraining him from holding himself out, participating in any parliamentary business. So that's the new state of affairs.
Supreme Court in the decision was a perpetual injunction.
No, interlocutory.
Interlocutory injunction. And High Court the was interlocutory.
Perpetual, because it's a final judgment.
Oh, okay. Okay. Now, what does it mean? Actually saying.
Okay. One say the Sebio, the cause is Obinaka. I won't say it's bizarre by novel.
Novel, next to a bin seed.
A bin seed.
You need precedents in law. Maybe number of case laws in the authorities. I would want a laws in a bin
seed. Say Supreme Court ebe use the original jurisdiction, and in that process purport to enforce a judgment of a High Court.
Okay.
It is novel. Completely novel. Rakwame, look, okay, Justice Nene Amegache, the dissenting opinion now. It makes very interesting reading. Or see, Rakwame, when I will say, per your own affidavit, or the bar court, no, will say, one your judgment. This is what you yourself are saying. And that in that judgment, the defendant has been perpetually restrained. What's there? Appeal it has been struck out for non-compliance. So there is no pending appeal. It in an Amegache say. So if there is no pending appeal, what do you do when you have a judgment? You go into execution.
To enforce it.
Lawyer need be our law school any sadi. It my lord na
me fan say me no obi atwa asase ho manso. Now a court no rule amami.
Exactly.
And nipa kro no anko the appellate court for
Dabi.
Wanko baby a. It me de metimi asa ko dwan atwa court ne say court no emame
enforce it.
Many execution of
possession.
Exactly.
Na wakoje asase a eye wodia.
Media no so
na sisi ano ukura judgment no wa exhibit judgment no. And now the Supreme Court say uni me wo judgment
wabra appeal bia enimu from the defendant.
Exactly.
Okay.
Na onipa no kra no appeal our file kra no eventually they are striking it out for non-compliance. Inti yeke say oni appeal bia. Sebiu to oni appeal bia. What it means in law, and they say you have a judgment against him, Anna.
Mhm.
So go and enforce that judgment, Anna.
Simple.
Anything, and then my lady Agnes Doji, I can say the way who know it is like an academic exercise. In fact, Nana Mega Chekra they offend legal ingenuity. Because it has never happened. Look, I'm challenging any lawyer to tell me where a party has a judgment from a high court, our Supreme Court, to have it enforced that. I'm looking forward to this opportunity.
Because metwase year whether a appellate court and answer the high court no se minya judgment wo wie na se nipa kro am file stay of execution baako anase wanya appeal bi to that effect of the
Are you not the victorious party?
yes it and who in answer me sa akọ the higher court na mo hono court no rule ma me no na me na force judgment ama me
na wonim the SIR who say oh, even though one judgment against him, no, he's holding himself out. What it means in law is that he's disobeying the orders of the court. And Brakwame, your Constitution 1992 said the superior courts have the jurisdiction to commit to themselves contempt of court. It is a me disobey the judgment of a high court, and the person is in contempt. I don't go to Supreme Court to enforce contempt matters against a decision of a high court. Two, if I disobey the orders of a court of appeal, how do I go to the Supreme Court and say, oh, Edudzi had disobeyed the orders of the court of appeal? Supreme Court enforce it against him. I mean, sometimes one control one.
That my menu we say no the issue about ne say we Ghana ni onye Ghana ni we call this some ye dey civil one na maybe so.
You see, Black Kwame, and what we say a very fundamental question. Okay, my Lord Justice Nana Megache and the dissenting opinion now, or can be very profound. But so one of the reasons why you don't grant this kind of injunction, and you say it has the effect of prejudging the substantive matter.
It is an open beside in my preamble say, Babu. Issue no the call Supreme Court a rule say me fancy abo obi kwa this wakum nipa na nipa no wode na kotumwa bi about 10 years ye be dia sem ne be wie no aha ye be dia sem ne be wie na oni fanyo ne kum nipa no sabi
ni
wakodem eti we say no na me bisa say yes ye injunction from any
semental law form ma
Mate.
No, because you see, our appreciation of the law of injunction is admirable. Because you see, the whole essence of an injunctive relief is to maintain the status quo. Una will say a writ is before you. A writ, and this is electoral dispute. And yes, as a class more. It's about representation. Osha MPP, ye presidential election petitioner, ye injunction Mampedino. When was that?
Na low Winim, Mammy how na General Secretary, so make a meeting, me and Masaba also. Why? Mate. And my main fan is not mess about so. And because the menu matters of law.
No, on any boss.
Imagine you have a afro. You.
Yeah, Papa, could you back up?
Could you back up? Yo.
OKFM 101.7.